Hello and welcome back to Hill and Ponton Social Security Disability Blog. I'm Natalia, Jofre, our Social Security Director.
And I'm Shelly Mark. I am the Senior Social Security Attorney.
So we had told you all that we would be talking about different cases and things that you can learn from those different experiences that Shelly has had. And she's going to share those with us.
Yeah. So we were discussing credibility.
Yep.
And so I'm obviously not going to name any names in our examples.
Mm-hmm.
But there are some cases that stick out more than others as we go through these issues. And I had one case in particular where the claimant had been injured in a motor vehicle accident and was very, very adamant that there was no alcohol use at the time of the accident.
Okay.
The issue in the case was that the medical records said the opposite of that. The medical records found that his blood alcohol level was high.
Okay.
And so when we discussed the case with the client, we were just very open in the fact that, okay, we need to be prepared to explain to the judge why you had alcohol in your system at the time of the accident.
Right.
And for the next 10 months that the case progressed, every conversation I had with that client circled around him telling me that he didn't have alcohol in his system at the time of the accident. And there's
if it's in your records,
right. If it's an error, then there's nothing we can do about it. But the point here is that if he would have just said, yes, I had alcohol in my system at the time of the accident, that's something that we can go before the judge and we can work with, and we can say, yes, this person had alcohol in their system, but look at all the records since then. There's no ongoing alcohol use or anything like that. In that particular case, there was ongoing alcohol use that the client was pretty adamant was not happening as well.
So it was mistakenly not only in one set of records, but in multiple sets of records.
That is correct.
But he thought that if he wished it away enough or convinced you that it was all erroneous lab work, that then the judge would also choose to ignore it.
Exactly.
Which is so highly unlikely. I mean, that's what they're going to base their decision on, is the evidence. And you have to confront those issues head on. I mean, they're going to come out no matter what.
Right. And if you have an attorney that's not addressing those issues, that's not to your benefit, because you're going to be sitting in the hearing and the judge is going to go straight to it and say, why did you have alcohol in your system on this day and on that day? It's just not something that's overlooked. So you need to own it, be prepared to discuss it, and then move on. But the worst thing you can do is to continue to deny it.
And I mean, obviously, it's not going to favor your case to have drug or alcohol issues. We would never say that or encourage it or whatever. But I mean, we have won plenty of cases where drugs and alcohol were, in fact, an issue. Not as much drugs, but like I know that one of the big examples is like veterans with PTSD that self-medicate in order to deal with, all of their problems and symptoms. And so if you kind of confront it and just say, this is why I drink, or this is why I do this, or whatever. I mean, sometimes the judges award those cases because they feel like, well, all of these problems would still exist regardless of whether the person has a substance abuse problem.
Right.
So they're not ideal cases, but they can be won depending on what the circumstances are.
And in that particular case, there was also an issue of submission of evidence. And that may be a good topic for us to discuss on our next blog, if you want to do that.
All right. That sounds good. If you have any questions or concerns in the meantime, feel free to call our office or visit our website.
Thank you.